Hold on a minute.
Yeah.
This is cause number M330184. Case is style of state of Texas versus Franklin Derek Goki. Mr. Goki, is that your full name?
Yes, sir.
How you doing, Mr. Goki?
Good, how are you doing?
I'm doing fine. Thanks for asking, Mr. Goki. You're representing the case by your attorney, Terrence Macon. Attorney Macon, how are you doing?
It's good to see you, Your Honor. I'm doing okay.
Humphrey. And the state is represented in this case by Attorney Kobe Hopper. Attorney Hopper, how are you doing?
Good, Judge.
Okay, Mr. Macon, what is your announcement? Hold on.
Your Honor, Mr. Gokey's finished the veterans program.
Okay,
He has pending felonies in Hardin County.
right.
I'm very close to disposing of those, and once that happens, we have a deferred adjudication offer in this case, which I feel we'll be taking at that time.
Okay,
That's fine.
now let me ask you this here. Your Hardin County case, when is that set? Do you know?
It's reset for November 11th, Judge. I went.
Okay, so we can set this after that.
Yes.
Okay, give us.
It's 11th or 13th, Judge. One of those.
What did you say?
11th or the 13th of November.
Okay, we'll set it maybe a week after that.
That'll be fine.
But it'll be the week in December. The 4th week. Okay, Mr. Madlock, please put the mic on mute. Madlock, please put your mic on mute.
Oh my goodness, I'm trying to figure out how to, sir.
Okay, I'm gonna put it on mute for you.
Thank you very much.
What is that date?
29.
Okay, Mr. Goki, your case is going to be reset to November 29th, 2023. Your attorney will get you reset. Once you get your reset from your attorney, you'll be free to go and you have a blessed day.
Yes, sir. Thank you.
Okay, and you're free to go as well, Mr. Making you have a blessed day. Okay. I'm gonna have to get Mr. Madlock to take his mic off of mute now. Yeah, Mr. Madlock, you can take your mic off of mute.
Hey, I see it. Okay.
This is cause number M333770. The case is styled the state of Texas versus Alton Leroy Matlock the fourth. Mr. Matlock, is that your full name?
Yes, sir.
How are you doing, Mr.
Yes,
Matlock?
sir. Good yourself?
I'm doing fine. Thanks for asking. Mr. Matlock, you're represented in your case by your attorney Lindsey Scott. Attorney Scott, how are you doing?
Good, Your Honor.
State is represented in this case by Attorney Erica Porter. Attorney Porter, how are you doing?
Doing great.
Ms. Scott, what is your announcement in Mr. Madlock's case?
We'll set a trial, Your Honor,
You set for trial, okay. Give us a reset date.
December 4th.
Okay, this case will be reset for trial December 4th, 2023.
Thank you, Your Honor.
And Mr. Madlock, you need to be in court in person on that day. Your attorney and your bondsman will be given notice of your reset. Once you get your reset from your attorney and your bondsman, you'll be free to go. Well, once you get your reset, just stay in contact with your attorney and your bondsman. Okay, now you're free to go and you have a blessed day.
Yes, sir. You also.
And Miss,
Thank you, Your Honor.
okay, you get your reset. How's that? Next case is Craig Haney, cause number 23CC Ciara 0068. Is he here? Oh, okay.
He's a couple of minutes away.
Okay, we'll recall it. Next case is Hunter Parker here? Okay, next case is cause number M334034. Case is style of state of Texas versus Hunter G. Parker. Mr. Parker, your name is Hunter G. Parker?
Full legal name is Hunter Gibson Joseph.
Hunter Gibson Joseph Parker.
Yes, sir.
How you doing, Mr. Parker?
Good today, yourself?
I'm doing fine. Thanks for asking. Mr. Parker, you're representing the case by your attorney Benjamin Jeffries. Attorney Jeffries, how are you doing?
Doing well, Your Honor. Thank you.
That's good. Now, Mr. Jeffries, what is your announcement in Mr. Parker's case?
Today, Your Honor, we're in communication with the state.
That's correct, Judge. We're working out, I think this will be resolved, Judge. We just have to work out the restitution issue of the amount.
Okay,
So we're close. We just need another reset.
okay. Hold on a minute.
Not, just needs to go to announcement. Another,
It's still on announcement. Yeah, it's on.
say another announcement.
Phone's ringing off the hook. We're gonna need a reset date for Mr. Parker announcement.
December 4th.
Okay, this case will be reset to December 4th. Mr. Parker,
Yes, sir.
once you get your reset from your attorney, you'll be free to go. You have a blessed day. Mr. Jeffers, I think this is your last case.
Correct.
You're free to go as well, and you have a blessed day.
Yes, sir. Thank you, Your Honor. Thank you for your time.
Okay, you welcome. Is that your? Mr. Time? Bruce Smith. William Wilkerson. Lawyer. Yeah, I know.
That's my case. Mr. Taney, we're waiting.
No, he's here. He just walked in. Court is in session in clause number 23 CCCR 0068, case is styled State of Texas versus Craig Tahaney. It's
Miss Scott.
okay, this is Mr. Tahaney, your full name is Craig Tahaney?
Craig Taney the second, Your Honor.
Craig Tahaney II. How are you doing, Mr. Tahaney?
Doing okay?
That's good. Mr. Tahaney, you're representing this case by your attorney, Lane Walker. Attorney Walker, how are you doing?
So far, so good, Judge.
That's good. Now, I think the last time that we were here, this is a gentleman, I think y'all, the state had made an offer about defer or something like that.
Yeah,
State, y'all had some argument.
well, actually, Judge, this was one of the ones where the state's abandoning the 0.15.
Right. And I think we really had I think,
You asked me to research it.
did you do that?
Yes, sir.
Oh, man, I didn't get it. I need it. Is it, do you file a brief?
I did not file a brief.
Because I thought we asked that, that if, do you have a brief with you or something?
No, sir, but I have the law. I mean, it's simple, Judge, it's simply section 4204. I mean, it's just that simple. I'll tell you, after spending a lot of time researching this issue, there is no case from anywhere on this. The reason that there's not is because under 4904, it specifically states that it
You
has
said,
to
hold on a
be.
minute, 49.
Yes, sir.
You're talking about, that's something, you're talking about the DWI statute. Mr. Can't have any drinks, any food in the
I
court.
was just, well, I take allergy medicine, so
Okay,
I don't drink.
49.04. Okay. Okay. 4904
Yes, sir.
D.
D. And then it says 100%, it has to be shown at trial. And a trial is not a plea, as the court well knows. The state has to allege it as an enhancement. They have to prove it beyond a reasonable doubt. If that does not happen, then under your discretion, under 42A102, it says that if the defendant is not charged with it, then you can certainly grant deferred probation because it's Class B misdemeanor.
Okay.
And I would submit to the court that the legislator used the word trial.
Yeah, okay.
To demonstrate that it was a contested issue. The state alleged it, the state pursued it, the state moved forward on it. And after a contested issue, albeit between attorneys on a plea bargain, it definitely has to be an issue where the state never backed off of it or abandoned it. And once they do abandon it, for an example, if the state was to dismiss this information and simply refile the case as a Class B misdemeanor, then there's no issue.
Right.
Or,
I think we've had that before, right?
but
You did that on another case.
But I mean,
Actually, there was a case
but
involving
the state,
Kevin Lane.
the state's contention is with counsel is that that's unnecessary.
yeah, it's been amended.
Okay.
All it has to do is abandon the allegation.
Yeah.
Okay. Let me look at this. I'm gonna read 42A102. B,
It's B,
yeah.
2.
Yeah.
It's double I.
The,
Judge, if I may, if you don't mind,
yeah,
the court never gets to 42A-102 unless one of two things happen, either a trial or a plea. So you have to cross the bridge of 4904 with or without an enhancement before the court ever crosses the bridge of considering its authority of which type of probation it can grant. So with that, if by the time you get to 42A-102, if it's only a Class B misdemeanor, then 42-102 is clear that you certainly have the right to do that. The language about whether or not it's a 0.15 or more is never a matter for the court to consider at that point, with all due respect. I mean, that's just what the law says.
yes, but what I was looking at the conflict between 42A.102, where it says that B.
It's B2, B double I. Says that.
No. I'm going up to B 1B under 4904 or 4906 penal code, and at the time of offense. The conflict that I'm talking about is this statute says at the time of offense.
Understood. But you
And,
don't have-
okay,
I'm sorry.
and and this says, and under 49.04 says, if it is shown on the trial of an offense.
Correct.
So that's the conflict that I'm looking at.
But Judge, if I may, the court has on blind. The court considers the evidence that's before the court. And there is no evidence, zero evidence before the court. If there is no enhancement, there's no evidence for the court to consider as to whether or not a blood draw or a breath test was a 0.15 or greater. There's just simply, it doesn't exist because that's his burden. You can't look at a probable cause affidavit that's in the file and say, oh, they found probable cause that he was 0.15 or better. That doesn't cut it, because the only way the court can make a finding in the case is it has to believe beyond a reasonable doubt.
Mhm.
So the issue under 42A-102 of whether or not it was a 0.15 or not never comes to the court's attention. Now, if he proved beyond a reasonable doubt, whether to me and Mr. Dehaney through a plea bargain agreement, and we pled on the Class A misdemeanor, and we pled on the enhancement, then yes, sir, you have no authority at that point. Or if we had a jury trial or a bench trial, and the jury or the court found beyond a reasonable doubt that he was DWI and he did prove the enhancement of 0.15 or greater, the court has no authority. But we're assuming that we go from 4904 with the enhancement, or we're assuming that just because there was an allegation of a
No.
blood draw.
Okay, I'm not assuming that we're going on 4904 with the enhancement, because the way the statute reads in 42.102, it says under 49.0, well, it is. In all other cases, the judge may grant deferred adjudication, community supervision, unless the defendant is charged with an offense, and then one of the offenses
Right.
under B is 49.04. Now, when they say 4904, they don't say 49.04D. It's just 4904. And so just doing a literal interpretation, if we looking at the way they wrote the statute, it suggests that anyone who has not a breath, but an alcohol concentration level of 0.15 or more, whether or not they're charged with A or B, that's the way I'm saying, the way it's not a well-drafted statute. And then what I'm trying to do is I'm trying to get the legislative intent from the statute. That's what I'm looking at, but I hear what you're saying.
Can I ask you
And
this?
yes,
Is maybe I'm confused because it's clear that the legislators in 2020 passed the law that you can get deferred probation
Yeah,
as
2019.
long as you're a .14 or less, okay? There,
0.14.
yes, sir, as long as you're under a .15 or
Yeah,
greater, you
less,
can
yeah.
clearly get deferred probation. So, I mean, is that?
Well, I mean, it's the discretion of the court that they can,
And-
that they may be eligible.
Eligible.
Right, right.
Yes, sir.
But here's my, I apologize. If we're looking for statutory intent, legislative. intent,
Right, right.
Right. If we follow the reason, not that, and I'm, with all due respect, if we follow the reason we're talking about, that flies in the face of 100 years of how we interpret prosecutorial discretion, meaning we decide what we charge, not the court. Now, if the court did, then yes, then you don't need to prosecute. The prosecutor decides what to charge. If we abandon it, like we abandoned enhancement,
I understand that.
then it never gets to you. Like we're saying, it doesn't, 42 doesn't even apply because you don't even have to look at it because it's just the DWI.
I know, no, what,
Play those terms.
I think you kind of
Well, I mean,
not completely understand what I'm saying. Okay.
I mean,
Well, what I'm saying, I'm just saying, the way they wrote the statute here, it does not say unless a person, it says 49.04. It doesn't say 49.04D, 49.04, AB, they just say 40. So that general statement of 49.04,
Sure.
that includes a B, and it also includes a A. You understand what I'm saying?
yes,
So what I'm saying is, I'm not saying that you are right or wrong. I'm just saying from the perspective now what he said today in reference to what 49.04D says in reference to if it is shown on the trial of the offense, right?
yes.
That's different from 42A.102. You understand what I'm saying?
Yes.
And so let me do this. It's just gonna take a few minutes. And I'm gonna take it under advisement. And we're gonna look at it again. And then we'll make a decision. That's all I'm talking about.
You
Okay.
got it.
Okay,
Thank you
All
so
right.
much.
Okay. Yes.
okay. Okay, we have Mr. Gregory here. Mr. Gregory. Mr. Gregory. Oh, I saw you in there. I was looking when I was looking, I didn't see your name on the doc.
Well, I spoke to Mr. Gregory.
Yes.
He's got a bond issue he'd like to bring to the court. The state
Oh.
to join. It's not on the,
Okay, give the name of the, give the name to our court partner. What's the case? Okay.
really, no, just before, you don't even need the name, but I need. The complainant in another case.
So it says, so you got
I
a
got
conflict?
lost file kind of deal that right now.
So y'all got a conflict?
Well, that's not the issue, the issue, but that is there, so we.
My issue is, we
Yeah,
have,
yeah.
the defendant in this case, it's a harassment charge. The victim of the harassment is an ex-wife with whom there are 2 children.
So ongoing.
And so I have a pending matter before the family court. And the issue here is that the standing orders of the court,
Of which court?
of this court.
Okay.
Your standing.
So he
orders-
has, so they have a bond conditions.
That is
Pull
correct.
pull
I have a-
those
I have a
bond
motion-
conditions.
I have a motion, and what I'm asking the court to do is to substitute the requirement of your bond and instead ask that the order that they comply with the district court's order.
Okay,
And that way the man can go up to the school, because your order says he can't go to the school where his kids go.
it doesn't necessarily say that.
Well, I didn't.
It
want to-
says
I
that,
didn't want
they
him to
can't
get
go
into any
to-
trouble,
Yeah, yeah.
but the way I read the
Residents.
standing orders, I felt like
Give me-
there was that he would violate that order if he went up to school because she would like to be there. And so he's not
Okay.
to be anywhere where she's likely to be, not at work, not at
Which I
school.
think,
And school is specifically mentioned in the court standing order.
do you have a bond conditions?
Let's say, I have my file back in my motion, I've quoted.
That, what was that you just
That's
clicked
the
on?
motion.
I mean, if I don't have no bond
Pretty
conditions,
sure, Judge, because this is brand new, I think it might have come from the jail.
oh, the jail has bond
Oh,
conditions.
Well, this court has a standing order on bond.
Well,
And I'm
not
I
that,
don't
well,
want-
what we do, we bring them in and I give them bond conditions. Okay, because if he's never been given a copy of his bond conditions,
Well,
who is that from?
this is my motion to you in this
Yeah.
case to modify the bond condition.
I don't have no bond conditions. That's the point.
Well, I thought there was a standing order on.
No, we have standard bond conditions, but what we do is we give standard bond conditions to individuals. If they come to court, everybody is not on the, normally we allow the,
Conception, I assumed that if the court had a standing order on bond conditions, if he posts bond, then he is required to abide by those bond conditions, and that. is
yeah,
that
but
not
that's the
case?
magistrate is supposed to give them bond conditions. And if the magistrate does not, technically, he's not under any bond conditions right now. And I think what they were doing, they were requiring the bondsman to give him those bond conditions. So what I've been doing, because the magistrate hadn't been doing it, the bondsman haven't been doing it, and so I've been giving bond conditions here. Apparently, he has not appeared before me to give him any bond conditions.
It just,
That's correct.
it's brand new, but the state is aware of it because of what I said before.
Yeah, but
It's
if
ongoing.
once he appears before the court can now, I guess based on what you're saying, they have children, he have visitation, he has a family court order that's in place. And normally what we normally do in that instance, like we did yesterday, we just strike out, we'll modify it and say, the person cannot talk to the other person in a threatening or harassing manner.
Which is essentially what the district court has.
Right, that's what we do.
Okay.
Yeah, but we don't have one. There's no
All right,
orders
so-
now.
All right,
So he's
my
under
motion-
that.
My motion is apparently moot. because
Premature, I guess.
But,
Premature would be another way.
but it's not, but it is at abundance of caution, Judge. This is an ongoing situation. that
Yeah, but I can't revoke his
I'm
bond
not saying revoke.
if he doesn't have any bond conditions.
Understand. And we made it where, so we're clear on what his conditions are now. I think it's good that council knows and the court knows. Our court also knows, and I'll let you know again when it gets on there, that we've got a cross file situation,
Okay,
which is, it's got its own unique.
but I normally, when y'all usually have crossfires, I think the state usually recuse itself, you get a special prosecutor.
Well, in this instance, the first case is the current husband of
Oh,
It's
the
a,
wife.
okay.
Now, 10 months later, wife files on husband.
Okay, that's a little different.
You know, a year
Isn't-
ago, my client files on her new husband.
Okay,
You know, step is.
yeah, he filed on the stepdad, okay.
So the daddy files, start charges on the stepdaddy.
And then the wife files on
Now, you
him,
know, 8
Okay.
months or 9 months later, there's an incident allegedly
right,
where wife now files on
Right.
the daddy.
so that's not really.
And that's the
kind of-
crossfire, you know,
yeah.
the state's in the middle.
I'm
Yeah,
in
I
the middle
understand.
and
Yeah.
I won't get into details.
Yeah, no, you don't need to
No,
do
we're
that.
not into discussion.
Yeah.
That's just kind of the moving.
I understand.
Yeah, so we just want to make sure that bunch
Yeah.
of caution that,
But at least you're on top of it.
well, hey,
You're a little ahead, but you,
it ain't good.
I understand. Yeah, that's why I always ask, like, to see what's in the file, because technically, I can't file any,
Well,
I can revoke a bond if he doesn't have any conditions
okay. And my-
that he's aware
and
of.
my misunderstanding was that I thought that when he made bond, that the conditions automatically.
But you have to give them conditions in their presence. You can't just say you're under conditions that you're unaware of.
Yeah, well, he's not under conditions at this time.
At this time,
Technically, all right.
yeah, other than the court order,
Okay.
other than the district court's order.
Thank you.
All right. This is cause number M334306, case of style of state of Texas versus Richard Anthony Damon. Mr. Damon, is that your full name?
Yeah, Richard Anthony.
Okay, Mr. Damon, now, how are you doing? You doing all right? That's good. I'm doing fine. Thanks for asking. Mr. Damon, you're represented by your attorney, Ms. Marva Provo. Now, Ms. Provo is not here because she has been ill for the past 2 months. And so she's not here. Have you talked to Anita Provo, her co-counsel? Oh, ma'am, you come on up, Mr. Damon, I see you have someone with you. That's your wife. Okay.
To the office with her, what she got sick.
You-
And Sister called and asked, or they show up in court, they will move on the case for another day.
Okay, now, okay, she just wanted him to show up because his Miss Marvel Provo is unable to show up.
Yes.
Okay, so we can reset your case. We're gonna reset your case. We can't anticipate how soon it's gonna be before your attorney recover from the illness. But we're kind of keeping a close eye on it. Okay, so he's gonna get his reset. Once you get your reset from our court coordinator on the end, you'll be free to go. And Mr. Damon, you're free to go. Ms. Damon, you're free to go as well. And y'all have a blessed day. Please stand over there. Ma'am, hold on a minute.